This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Joviat. Tonight it's Ask Us Anything night. So call in your questions on any legal topic and we'll point you in the right direction. The 31 Law Call number 256-536-0077. Maybe you've got questions about what court is like. Maybe you've got questions about a car accident or something that has happened to you or a family member recently. Maybe you've got a family member in nursing home care and you worry about that and have some questions about that. Call in. You can also email a legal question. You can email any day of the week to lawcall@waaytv.com. And when we get to a show on topic, we pull some out. We've got some of your email questions waiting for us tonight. I've got with me Heath Brooks from Timberlake League. And Brooks, good to have you here tonight.
Good to be here.
Boy, it's foggy outside. I hope everybody's been careful.
I know.
Maybe everybody's been home watching the Super Bowl.
That's right. I hope so. It's like driving in a cloud right now.
It is.
So, be careful out there.
We always like to pull out some video before we start talking and taking your questions. We pull out tonight's Ask Us Anything question. This is a guy out on, so he's out biking as part of a road race. There's several of them out here, but in this case, the road goes right through the middle of where this bull is. Okay, so that's where that's where we bring in the personal injury attorney to, Heath, you guys do personal injury cases. I don't know if you've ever had anything like this, but if you're part of a road race, you would assume that whoever's planning this thing has put you in a safe location. Is there a problem with this?
Here's the deal. Whenever you do something like this, whenever you go out and you get on in a farm and you're driving down a dirt road and there are cattle around, you got a couple of different options, right? You've got an option to stop and turn around and go the other way. And in that kind of scenario, that's probably what you need to do. There's pretty much every time you enter a road race, you're going to sign what's called an assumption of the risk or a waiver of liability. Okay. And that waives responsibility to the people who actually are conducting the race from any kind of injury that you may sustain, unless those people's conduct would be considered reckless. And that is not the scenario there. The deal is, we were talking about this earlier. I mean, you see people driving around in Yellowstone and they run up to the bears and, with their cameras and the kids in their arm. And so,
elk and moose and bears, and what are they thinking?
If you see something like that, everybody knows a bull can charge you. If you see something like that, stop and turn around. If you continue to go, you're going to put yourself in danger. And if you put yourself in danger, it's on you. So,
Call in your questions, 31 Law Call number 536-0077. Okay, you're talking about signing waivers for things.
Right.
How about signing a waiver for your child? Does that hold up? So lots of these places, the trampoline places and all kinds of amusement parks and things, will have you sign something for your child, but it's a child. Does that count?
Here's the deal. So when you're a child, you are under the age of 19. The age of majority in the state of Alabama is 19. That means we don't become adults until we turn 19 in the eyes of the law. Now, we can still go get drafted in the military and other things, but in the eyes of the law, we cannot go and buy a car. We cannot form a contract. So when you go to one of these parks, your parents have to take it, and your parents have to sign away any sort of responsibility for injuries that may occur to you, the child. Well, the problem is that the law in the state of Alabama is pretty clear. Those waivers are generally not going to hold up if there is some negligence on the part of the trampoline park or of the water park. The parents can sign them all they want, but you can't sign away the responsibility for someone to take care that a child is not injured.
And believe us, they will want you to act like that's going to hold. Yeah, go see a lawyer.
I've seen it too many times, and come in and we see these waivers, and generally those waivers are going to be very strict. If you are an adult and you're in a trampoline park and you get injured, well then you sign a waiver. I'm sorry, that's the way it's going to be. You're not going to be able to bring an action against that water park, or trampoline park. But if it's a child, you can't sign away the responsibility there.
We've got callers waiting. We've got Jeff on the line with a question from Madison County. Hi, Jeff. Thanks for calling. What's your question tonight?
Good evening. Thanks for taking my question.
Sure.
Yes, I've had the same homeowner's insurance since 2006. Mm-hmm. I've only had one claim, which I was involved in the tornadoes of April 27th, 2011.
Yeah.
Mm-hmm. The same homeowner's insurance I have replaced my roof at the time because it was blown off.
Okay.
the other day I received an email from a retention part of this insurance agency, and they were stating I needed to basically put a roof on my house and then show them a receipt. There's nothing wrong with my roof. I have 25-year shingles put on in 2011. I have no leaks. What do I do? Can a homeowner insurance make me put a roof on my house?
Have you ever heard of that?
Well,
I wonder if it's phony.
It's
Jeff,
not a scam. I called and checked. It's
Okay,
not a
it's
scam.
legit.
Okay. Well, Jeff, here's the deal. An insurance company can make certain requirements. One is you need to pull your homeowner's insurance policy and go and talk to a lawyer and have them review your policy to see what happens in those kinds of scenarios. In other words, that may not be in your policy, and so that's something that is an aftermarket sort of deal that may have been added to your policy that they don't have the authority to do. But generally speaking, your homeowner's insurance carrier does not have to continue to cover you if you don't meet certain requirements that are in your policy. And so that's one of those things you've got to look at. But in a scenario where a homeowner's insurance company comes to you and says, hey, look, you got to replace your roof or we're not covering you, then you have a couple of different options there. You can say, okay, well, that's well and good, but there's plenty of insurance companies out there that can cover me, and I'm going to go to another one. You know, and so if that's something that your homeowner's insurance carrier is making you do and you're not happy with that, well, then you should have no loyalty towards an insurance company in that scenario. Go and look at your options. Go and see if somebody offers you a better deal. Pretty sure that's probably going to be the case. So, but if you want to continue with this insurance company and you want to see what kind of requirements they have over you, get your policy, review it with an attorney, and then that's going to give you the keys to the kingdom.
Good luck with it, Jeff. We've got Howie on the line with a question from Huntsville. Hi, Howie. Thanks for calling. What's your question tonight?
Yeah, hi. I have got a judgment here in Madison County against a gentleman who purchased a house a few years ago as a single man, and since that time got married, had his wife move in with him, and he signed a quitclaim deed to him from himself as a single man to himself as a married man, but never deeded the house to the wife. Then a couple of years later, they got divorced, and they've got a divorce decree that adopts a settlement agreement in which the husband moves out and the wife gets to stay in the house. And what I want to know is if I execute on this judgment I have against just the husband, the ex-husband, can I take possession? If I get the deed from the sheriff's deed, can I take possession of the property with an ejectment or an eviction or anything like that, or do I have to honor the divorce decree and let her stay there?
Well, here's the deal. You got two different issues there, right? You've got one ownership of the house, and who actually is the owner of the house. And then the second issue is if the person that you have a judgment against is the owner of the house, what can you do to take possession or to recover your judgment? So the first thing is in terms of evicting somebody, that's probably not going to be the proper process that you're going to want to go through because you're not a landlord at this point in time. And so there's not an unlawful, that's what they call that, the fancy legal term for forcing somebody to leave if they're a tenant and haven't followed the rules. It's called an unlawful detainer. And that's not where you are. So what you need to do is you need to, if you have not recorded your judgment in a probate court, then you need to record the judgment in the probate court, and then you need to attach a lien to that particular property if you have not. And then you can execute, then when the home is attempted to be sold, then, and at that point in time, there's an encumbrance, the fancy legal term for you can't sell it, an encumbrance on that particular title of the house, and that has to be taken care of before the house can transfer any sort of property. In other words, your judgment has to be paid. You can also force a sale of the property, and in order to be able to do that, I would highly recommend, I would highly recommend you retaining a lawyer to handle that aspect for you, because there are some things, some steps that you have to go through in order to ensure that when you sell that house and force to sell that house, which would be at auction on the courthouse steps after you've done all kinds of different notice requirements in the newspapers and whatnot, that all of those steps are taken to where you can force to sell the house. But in answer to your question, if he is the owner of the house, regardless if you can attach your judgment to that house and force a sell, then at that point in time, the divorce decree, you would be the owner. You don't have to abide by the divorce decree, I wouldn't think. But I would definitely talk to an attorney before you attempt to move through those wheels.
They're telling us take a break. We're going to take a break. Be right back answering more of your questions. It's Ask Us Anything night. Stay with us.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of attorney Michael Timberlake, attorney Will League, attorney Heath Brooks, attorney William Maservi, and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. It's Ask Us Anything night. Call in your questions. The 31 Law Call number 536-0077. Heath Brooks is here. Heath does personal injury cases, so that's everything from car accidents, medical malpractice, nursing home negligence, all of those kind of things. We've got callers waiting. Sarah is on the line with a question from Huntsville. Hi, Sarah. Thanks for calling. What's your question tonight?
Oh, yes. My question is, you've been in a house and lived there for 30.
Yes, ma'am.
Are you there?
Yes, we're listening.
Yeah, we're listening.
You've been in a house and lived there for 30 years?
30 years in a neighborhood.
Okay.
Okay.
And all of a sudden, a group of different people, just call them a cult, has moved near you or across you, and they continue to come at you because they have their ways of being and what they're dealing with and doing. You just don't want to be a part of it. What do you do to stop the harassment?
Sarah,
Okay.
give us an idea of what they're doing. They're talking to you. They come to the door and they want to talk to you, or what are they doing?
They're coming on the property, have left things, harassment. My understanding, I've seen them plug into our internet line. They got a lot of stuff. They got some things going on across on their property and land that has affected over here on my side because they deal in underground plumbing and stuff like that.
Okay.
It has caused us have to get off of a off of a septic tank and get hooked up to the sewer line where they had our property flooding.
Okay.
Okay.
They did a lot of things.
Okay.
What can you do with something like that?
Well, you have a right to enjoy your property. That's the first thing. You have a right of enjoyment of your property. And if somebody else is creating the inability for you to be able to enjoy your property, you can do a couple different things. The first thing that I heard you say is that they were coming onto your property. There's a lot of different ways that you can prove that somebody's coming onto your property. The first thing is get a little camera system and catch them, and then show to the police that these people are coming onto your property, and get the police to bring a charge for trespassing. And then that way, if they're trespassing on your property, then if they're trespassing on your property, then police can get them to stop. Second thing is if they're trespassing on your property and causing damage, then you may have a civil right of action against them for the damage that they've caused. And a lot of times, if you can bring a civil action against them, and when I say civil action, that's what I do. I bring civil actions against people for money damages. And so a lot of times that kind of action will talk and get people to stop. The third thing is that you can file for an injunction if it is a nuisance. And a nuisance is a legal term of art, but it basically means somebody is doing something that makes you unable to enjoy your property. A lot of times we think about things like your neighbor changed the flooding patterns of the neighborhood, and you've got a big flood that goes through the yard, or your neighbor puts a hog lot in the backyard and the smell is so bad that you can't enjoy your property, and you can ask a court to enjoin or to stop your neighbor from those kinds of activities so that you can enjoy your property. That is a lawsuit. that you would have to file. But that in the circuit court of Madison County, if you're in Madison County, or whatever county you live in. But that is where you go and you ask a judge to stop them from doing the type of thing that they're doing that creates the situation where you don't enjoy where you're living. And so I think those are some good options for you to take. But if they are trespassing on your property, that's your first step, is catch them trespassing, tell the police, and get the police to file charges.
Police can have them locked up. The charges that they bring, they may result in this person getting jail time, whereas a civil case, you're not getting jail time, right?
You're just asking for money damages. Okay. That's right. And you know, jail time is, in a first trespass, that's a misdemeanor. So normally you're not going to get jail time. But if you continually do that and you just flaunt yourself in front of the law, that's going to be an issue. And you know, it sounds like you may already be at that point where it is becoming a serious issue. I don't know whether you've gotten the police involved yet, but it may be time.
We've got Nick on the line with a question from Fort Payne. Hi, Nick. Thanks for calling. What's your question tonight?
Yes, I've got a question about trying to get malpractice case, and I'm having problems with getting attorneys to take my case because the doctor's daddy was a judge, and they don't want to take it. It's a conflict of interest.
Gotcha.
So my statute of limitation was running out December the 27th of 23. 2 years was up.
Okay.
Before it run out, I went and filed it on my own.
Right.
Because these attorneys, I've got some big attorneys that told me that I had a malpractice case, but they would not take it because of conflict of interest.
That's right.
So I was wondering if y'all had any suggestions on me getting an attorney to step in to help me with this.
Well, let me go ahead and tell you about medical malpractice cases. There are very, very few lawyers in the state of Alabama that even handle those types of cases. Those are cases that are very, very difficult to win, and it takes a particular set of facts. So, but before we get to that aspect of it, let's talk about the other aspect of it. If you're an attorney, and if you are, it doesn't matter whether it's a doctor, it doesn't matter whether it's another person that may have caused a wreck or whatever, but if you have represented that person before as a plaintiff, or if you know them personally, you may have a conflict. Sometimes your conflicts are personal conflicts where you don't really want to provide representation for personal reasons. That may be a family member, that may be a really good friend. And then other times there are legal conflicts where the state of Alabama does not allow you to provide representation as a lawyer for your malpractice case. So what I'm getting at is that if you are in a small community, and I think Sharon said you're from Fort Payne, so if you're in a small community and there's a judge in that small community that is related to a doctor, pretty much all the lawyers in your small community are most likely going to know that doctor. And so that would most likely be a personal, if not a legal conflict. And you're going to have a very difficult time finding any lawyer that really is even going to look at your medical malpractice case in that kind of a community. My suggestion to you is that if you're Fort Payne, get out of your community. Go to Birmingham, go to Madison County, go somewhere that is far enough away from your community where that doctor will probably not be known by the legal community. And then you'd have a better chance at a fair shake. Now, the second side of that is, what does it take to have a viable medical malpractice lawsuit? I can tell you that if I had $1 for every time somebody said, my doctor told me my medical malpractice lawsuit was good, I would not need to practice law anymore, because the reality is that a lot of doctors or nurses or other medical practitioners may tell you you have a good case, but any lawyer who does this type of work, what we're going to require is to look at your medical records. So if you want a lawyer to evaluate your case, you probably need to be gathering your medical records. The second thing is that in order to evaluate whether or not you have a medical malpractice case, then a lawyer is going to need to ask an expert, somebody who actually practices the same sort of medicine that the doctor that you contend caused you a problem. And so that's the two prerequisites that most law firms would take before determining whether or not you have a viable medical malpractice case. And I don't know whether that has occurred in your case, but if you filed a lawsuit, there are some specific requirements that you have to follow in the state of Alabama when you file a medical malpractice case. And so it would be critically important very quickly to talk to another lawyer outside of your area to see if you even met the requirements when you did file your lawsuit, because otherwise a defendant malpractice or the defendant doctor may be able to quickly have your case dismissed, and you may not have any other form of recourse.
A medical malpractice case is tough. It's not something you could do on your own as a non-lawyer.
Not at all. They're hard. They're hard. And I do them. We do them. But they're hard. There's a particular set of facts, and you know, a bad result doesn't always mean malpractice. And it can't. There's a standard of care that all doctors across the country have to follow, and we have to prove. We as the plaintiff have the burden to prove that they didn't follow that standard of care, and because they didn't follow that standard of care, you suffered an injury. And that sounds real easy, but every step of the way we have to have experts that are not us and they are not you, that are doctors, that testify that that is the case. And so it can be difficult to find doctors to testify against other doctors. Yeah. And that's kind of what we deal with.
Good luck with it, Nick. Mary's on the line with a question from Tony. Hi, Mary. Thanks for waiting. What's your question tonight?
Well, about 16 years ago, in fact, this month, I met up with a white cow on Highway 53. And the farmer came out, he was insured, all that stuff. And I found out Alabama has an open range law.
Yep.
Oh, I think we just lost you. Okay, I think I lost her. Open range law, what's she talking about?
Yeah, so this has been in place in most states in the southeastern United States. When you have a farm animal and your farm animal gets out of the fence, then it's kind of a get out of jail free card for the farmer. There's very few times where you can get around the Open Range Act, which basically means, and I grew up on a big farm in North Georgia. Georgia has this law too. If your cow sees the grass that's greener on the other side of the fence and gets out and causes a wreck, then you as the farmer, most of the time, are not going to be responsible. There are some very limited exceptions for intentional conduct. If you intentionally let your cows out, well, then that could be an issue. But if it is a situation where you are negligent in maintaining your fence, that is not going to be enough for the farmer to be held responsible. If it's there can be some gray area if the farmer, you know, intentionally is leaving gates open so the cows can go and graze in somebody else's field or something like that. But most of the time, you're going to be out of luck.
Interesting. Okay, we're going to take a break. Be right back answering more of your questions. It's Ask Us Anything night. Stay with us. If you didn't get your questions answered tonight, here's how to get in touch with Heath Brooks with Timberlake League and Brooks. They are personal injury attorneys in Huntsville. 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon Doviet practices family law. That's divorces, child custody. She can be reached at www.sharonfamilylaw.com or 256-539-7337.
In our last minutes, how does somebody pay for a personal injury attorney?
You know, normally with a personal injury lawyer, you don't owe a dime to a personal injury attorney unless they recover for you. That's how we do it. So, you know, as you go through the course of your case, if the personal injury lawyer takes your case and loses at the end of the day, then they eat their fees, they eat their expenses, and you walk away. And we shake your hand and say, hey, look, we did everything we could do. You never owe a personal injury lawyer unless you win your case.
Everybody have a safe week. Thanks for your questions.
Be safe.
Tonight. See you next week.